Former special counsel Jack Smith ripping Jim Jordan, the MAGA Republican, to shreds after Jim Jordan, who currently chairs the House Judiciary Committee, referred Jack Smith to the Department of Justice for criminal prosecution. Jim Jordan contriving and lying that Jack Smith lied during his testimony before Congress. We all showed you Jack Smith's testimony, both the initial deposition, which the MAGAs wanted to not show publicly, and then they are like, all right, let's try again, because the whole goal was to try to lay a perjury trap to then criminally prosecute Jack Smith. And, you know, Jack Smith went in there knowing that quite literally every word he said, even if it was an I don't recall or an or an ah, that Donald Trump and Jim Jordan and James Comer and these vile MAGA cultists would do everything possible to try to prosecute him by just trying to find any lie or anything. And so he was very careful. His testimony was very strong. He answered every question. He made it clear he would have answered more. But you'll recall that the MAGAs, working with Trump's DOJ, refused to allow him to testify about volume 2 of his investigation, the Mar-a-Lago document aspect of it, where Trump took the classified information. Although based on all of Donald Trump's war crimes and horrible behavior right now, that even just the notion of Donald Trump taking classified information, you know, to Mar-a-Lago feels kind of tame in compared to what he does any given day right now. And it's sad and sick that we've gotten here, but here we are. So Jack Smith is represented by Covington, one of the top firms in this country. They sent the following letter to Jim Jordan and Todd Blanche, just ripping Jim Jordan. It's succinct. It's a powerful letter. I want to share it with you because this is like just a perfect lawyer letter, aggressively dealing with these issues. He's represented by Lanny Brewer and Peter Koski. Let's take a look at what they wrote to Jim Jordan. Dear Chairman Jordan and Blanche, the House Judiciary's Committee referral to the Department of Justice of our client Jack Smith is based on a spurious claim that Smith provided false testimony during his 8-hour deposition on December 17, 2025. The referral is made not because Mr. Smith made a false statement. The letter concedes he did not, but because he did not proactively disclose information that was not responsive to a question asked. During his testimony, Mr. Smith provided truthful, responsive answers and candidly discussed his work as special counsel. This referral reflects a chilling eagerness to weaponize the justice system by attacking a career nonpartisan public servant who faithfully and fearlessly performed his duties by following the facts and the law. The purported predicate for this referral is based on the following exchanges. Question: did you seek a search warrant for the content of any text messages from members? Answer: from members. Question: yes. Answer: no, I don't recall that. Question: okay, it was just toll records? Answer: correct. Next set of questions. Question: did the toll records that you requested from the senators, did they include the content of the phone calls? Answer: no. Question: did the records that you requested, the toll records from the members of Congress, include the content of the text messages? Answer: no. Those answers, Jack Smith's lawyers write in this letter, are unimpeachably truthful. The toll record subpoenas that were the focus of those questions did not call for the content of text messages. The questions and answers preceding and following these exchanges also make clear that the focus of the questions was on the toll record subpoena. Notably, the referral letter does not contest the truthfulness of Mr. Smith's answers. Perhaps in recognition of this deficiency, the referral letter instead relies on the unprecedented theory that Mr. Smith provided false testimony not because of what he said, but because of what he did not say. Specifically, the referral argues that by not proactively disclosing that the special counsel's office collected from the National Archives records from the White House phones that included text messages between White House officials and Republicans and Democratic members of Congress, Mr. Smith violated 18 U.S.C. Section 1001, the federal false statement statute. The letter advances this theory even though that information was not responsive to any question asked. This dangerous theory of criminal liability has no limiting principle and risks ensnaring every witness who testified before a congressional committee who does not proactively disclose information that is not responsive to questions asked. Mr. Smith approached the investigation into Trump as he approached every other investigation throughout his career, following the facts and the law while adhering to the Department of Justice protocols and regulations. He was transparent in disclosing that these text messages to Trump's personal counsel in discovery. If Trump's attorneys thought that Mr. Smith and his team had done something unlawful or improper in obtaining these text messages, they could have filed a motion to that effect. Notably, they did not. Mr. Smith agreed to testify before the House Judiciary Committee, fully cognizant of the risk that Trump's Justice Department would try to find something in his testimony to serve as the basis for a criminal charge. This risk existed not because Smith would make a false statement, but because Trump has repeatedly ordered that Mr. Smith be prosecuted and jailed. That is not the rule of law, and it contravenes the principles that are critical to the vitality of our democracy. An honest assessment of the facts and the law compels a rejection of the meritless referral signed by his lawyers at the Covington law firm. Let's bring in Harry Litman from the Talking Feds YouTube channel, Substack, and podcast. Harry, I wanted to read the full letter, 90% of it, so people can understand what was being laid out there, how ridiculous this referral is, and that now the DOJ is not even referring people out for what you say or what you do, but hypothetically what they want you to do. It's now thought crimes that they are going to prosecute Donald Trump's political enemies for. It reminds me of that movie with Tom Cruise in the future where they start prosecuting people for things that aren't even done yet. And this is a dystopian modern day version of that. And hat tip to Covington for also staying in the fight when so many firms bent the knee. Harry, what do you make of it?
Wow. So, look, Covington did a smart thing by just starting with the words. If you listen to, spurious argument, thus and so, that sounds like what lawyers always say. But this case is a dog equaled only by the James Comey prosecution for the seashells of 8647. No self-respecting prosecutor would even give a moment's thought. I just want to say it again. Did you seek a search warrant for the content of any text messages from members? And so I think the Meidas Mighty knows this and Talking Fed heads as well. But there are two very different things that prosecutors can seek. A very common thing that doesn't require much of a showing, and the Supreme Court has said no expectation of privacy, is just a little readout that says, here's the number they called, here's how long the call lasted. That's really what you use it for. And as Smith actually explained in another part of his testimony, this would have been the stuff that you could say, what was going on January 6th? Okay, 2:15. Perry calls Meadows, 2:22. Meadows calls Trump. I mean, it's not only not sinister to do it, it's essential. Remember, all this stuff was going on the Hill, and we don't even know about this yet. But you have now a refrain of senators and members of Congress saying, you spied on the content of my emails and texts. And the simplest thing to say is, no, not at all. The law makes a distinction. Here is just the little metadata, as it's called. And then here's the text. And you can get that, but with a much higher level of proof and subpoena, et cetera. That's a serious expectation of privacy issue. So when they ask, did the search warrant, it's a search warrant, they're asking a specific one. Did you seek a search warrant, which would be what you would do for the content of any text message from members? No, I don't recall that. Just toll records. Correct. And then you go on. Did the toll records that you requested, did they include the content of the phone calls? I think this is actually friendly questioning, making clear that the senators Hawley and others who are up in arms just don't know what they're talking about, or they're trying to fool the American people. And Smith is calmly explaining, no, no, no. What I got is just the metadata. And I'm here to hopefully calmly explain that is such a routine, standard, required move in this sort of investigation when they're trying to put together what happened on January 6th. Did the records that you requested from the members of Congress include the context of text messages? No. All right. And here is the theory. It is so harebrained, so nuts. Is he received from the archives. The archives gave Smith some records that it had. That was, and those records were turned over from different members of the administration, different members of Congress. That's a standard thing at the end of an administration. They give it to him, and some of that, in fact, is the content of emails and the like that was sent to the administration. The notion that here, where they're asking, the toll records that you requested, were you getting at email content? That the right answer there was no. Oh, but you know what? A whole different thing way back over with the archives gave me, that is, it's not simply, you've handled depositions a lot, and you tell the witness only to answer the question presented, but that's not even this. We saw him. He was candid within limits. But this is not a question that anybody would think would call for the revelation about things from a whole nother subpoena, a whole nother party that happened to have the content of some messages. The idea that he's misleading here really is spurious, but I mean, spurious as the day is long. There's an interesting thing going on that, you wonder right away. They did it to Comey. They've done it to others. Will they just green light this referral? And, was Jim Jordan's the fix already in? And I think the short answer is, I don't know. If they indict him, among other things, and he's got good counsel, as you said, Lanny Brewer from Covington and Burling, among other things, I think he's got a very good argument that for his own defense, he may need access to his report that they've been trying to keep out of his hands and out of the hands of records within the court, in general. And it's going to, in some ways, relitigate the whole, both prosecutions, especially the January 6th one. And I don't think I need to remind you, or the Meidas Mighty, but this whole propaganda campaign to make it look as if it went away and Smith made up these cases. Those are two righteous cases with really overwhelming proof against the president of the United States, who only by the happenstance of the Supreme Court and an election has escaped the noose there. And so, it might be really a kind of Brer Rabbit thing for them to now actually indict Smith. And I'll tell you, if they do, on this record, I can't see this going to trial. There's no special thing. Rather, I think that as you know, there's an immediate kind of motion you can make to a judge that says no reasonable juror would convict on these allegations, and on that basis just dismiss. Or it'll go to, if it goes to trial, there'll never be a conviction. This one, they stretch. They really do some very poor, under-supported, under-proven things. This one is just a frigging joke. It's the weakest false statement case I have ever seen.
It is the seashells of false statement cases. It is the reflecting pool of seashells of false statement cases. And, we develop a body of kangaroo court case law. And Harry, you and I may do a video on this as well that the Meidas Mighty can look for. You look in places like Ecuador, where the prosecutor who was investigating a lot of these individuals who Trump was trying to kill on these fishing vessels and these ships, who were missing, and what happened to them, and were they being tortured and all that. The prosecutor in Ecuador, under a Trump dictatorship in Ecuador, gets killed. And, you take a look at the systems in other countries and just the way their legal systems, are full kind of, kangaroo court, law of the jungle type of situations. This is what Trump wants our system to be. You'll get prosecuted for seashells, for thought crimes, for Trump putting hydrogen peroxide in reflecting pools. And it's why I'll end where I started, which is you take a look at the classified information charge against Trump. And in a way, it feels quaint. Oh, Donald Trump brought some documents back to Mar-a-Lago and he was going to maybe give them to Saudi Arabia. It's like, okay, that's Monday before 8 a.m. I know he's commander, he's the president, but like the things that he does every day make this stuff look like, like the C team of crimes compared to what he does on a given basis anyway. I can go on and on and on. But the point is
and that don't even get us started on the emoluments clause. That's for another tape.
But get me started on everybody going to Harry Litman's YouTube channel. It's called Talking Feds. Search in YouTube, Talking Feds, and then go to his YouTube channel. Tell Harry that I say hello, that I say WTF Harry. Ben says WTF. Pre-order WTF America. Right now it comes out in October. But everybody go to Harry's YouTube, Talking Feds, and subscribe here as well. Thanks, Harry.
Thank you, Ben.
Breaking news right now. My brothers and I wrote a book. It's called WTF America. And well, doesn't that just say it all? It comes out officially this October, but you can pre-order your copy today. Just scan the QR code or click the link in the description below.